Senator Goodall, Representative Duchesne, members of the committee. My name is Andrew Fisk, and I'm the Bureau Director for Land and Water Quality at the Maine DEP, and we are here speaking in opposition to the bill. Again, as the department and the administration testified on some of the prior legislation, we would acknowledge very heartily the wide range of public interest in both groundwater and surface water, and the high level of citizen engagement in this issue is in fact very comforting, even though we stand here in opposition to this particular bill. It is very important for citizens to be interested in water, whether they own it or not, and to make sure that there's an adequate framework in place to ensure that it is stewarded for the long haul. So why are we in opposition to the bill? It is unnecessary. First and foremost, I would say all of the issues that were raised today are legitimate issues. Questions about groundwater quality, groundwater quantity, surface water quality, surface water quantity, allocation, and who is doing what with water are perfectly appropriate questions to ask. That said, you do not need to make water a public trust or change the property right interest in water to answer and abide by those questions. The police power is a well-established authority of the state. When the legislature asserts a public interest, which you have done already in groundwater and surface water, regardless of who owns it, you have asserted time and time again, Representative Adams went through a number of instances of that, when you have asserted that there is an interest of the public in this private property interest. This private property interest in this case is groundwater. You've done it in many other things. Underlying law that relates to land use, the authority to plan or create local land use ordinances. The state has said you have a police power interest to protect public health, safety, and welfare by regulating land use. You have done exactly the same thing with groundwater. So our position is you needn't go into this fray of who owns groundwater in order to maintain a coherent regulatory and planning framework over the resource. That said, what is the regulatory framework and how does the connection between surface water and groundwater work? It is of great comfort to have many, many citizens say, as they have told you today, groundwater and surface water are connected. Absolutely correct. I stand very confidently, as Maggie Shannon has noted, in the middle of an archaic property right framework. The property right framework around groundwater is non-scientific. In fact, it's earlier than the 17th century. It goes all the way back to medieval times. Property owners owned everything up to heaven and everything down to hell. It was a simple way to allocate property interests. So I stand very confidently in the middle of that because of the police power. So the framework that exists, as we've talked about generally in front of the committee, asserts all manner of public interest. So let's talk technically how groundwater and surface water work. Again, groundwater is classified in state law. There are two classifications, GWA, GWB. There is no classified groundwater that is groundwater B. It is all groundwater A. Groundwater A shall be protected so as sufficient for drinking water quality. You have asserted that regulation and that power. How is that manifested? It is manifested in my work in water quality. It's also manifested in a number of laws that you have enacted topside, where you've said, you know what? You can't put above ground storage tanks over significant sand and gravel aquifers. You can't put above ground tanks there either. What you've done is you've controlled private property to protect the values of groundwater on anybody's property, whether the tank is on top of their own land or on someone else's water. In terms of the groundwater quality and the metrics, Andy Tolman has spoken to you about how the drinking water program works and all of the maximum contaminant levels that are asserted on groundwater to measure its quality so that it is or is not sufficient for drinking water. When it isn't, we're obligated to clean it up, and you put a lot of resources towards cleaning up groundwater, and you've touched on some of the related issues of that today. Surface water, as you know, is also classified. Flowing waters have a classification AA, A, B, or C, and as noted, the Clean Water Act provides that those classifications protect for fishing and swimming and aquatic life and any other use, including drinking water after disinfection, hydropower. You have all these designated uses that you've protected for in surface water. There is a difference between those. The Clean Water Act does not cover groundwater. It only covers surface water. However, state law has filled in behind the Clean Water Act and put a regulatory framework in place. So you don't have a statutory disconnect. You don't have a regulatory disconnect at the state level. For example, how does it work with regard to significant groundwater extractions for, let's say, a bottled water company? As we have described to you in the past, and I would direct anyone to the DEP's website, go to Land and Water Quality and search on significant groundwater wells. You'll see an entire page that describes the regulatory framework, and as importantly, you will see copies of permits that we have issued. When we regulate a groundwater withdrawal, we require sufficient information from the applicant to understand the aquifer from which they are drawing water. Describe the aquifer and tell us how much you will be withdrawing from that aquifer. Tell us what's going to happen based on your pump tests and modeling to that aquifer when you extract it to your proposed level. Give us all that information. In terms of drinking water, bottled water, spring water, as we've described to you before, that has to have a spring that is protected. So in that instance, there's actually a commercial obligation to make a connection between groundwater and surface water. Even if that didn't exist, state law requires that when you bring in all that pumping information from your well, we protect surface water flows. So we have information that is required by law that we evaluate as administrative agencies, either the DEP, or the Land Use Regulation Commission in the unorganized territories, or the Drinking Water Program at Department of Health and Human Services. We know that when you propose to pump some level of water from that aquifer, there are potential impacts to surface waters. So we impose conditions based on the information that we have been given by the applicant and independently evaluated, that when limits are imposed on the permit, they will ensure that the streams still flow at levels that protect aquatic life. And as we've described to you before, we have very sophisticated mechanisms to know when aquatic life is protected. We impose cubic feet per second limits on streams so that those bug communities that we described to you maintain the classification status that is listed in law. Same thing for lake levels. We had described to you generally the recent NERPA permit, significant groundwater well permit that we issued in the Freiburg area. That permit relates the groundwater level to the lake level of Ward's Pond. Similarly to the extraction that Mr. Merrill described to you about the Freiburg Water Company and that withdrawal in its relation to Lovewell Pond. We know how the groundwater and surface water relate to each other, and we require that there be conditions in the permit with verified numbers that protect for the flow in the stream or the level in the lake. The permits are conditioned such that information is submitted to us upon operation. Over the life of the operation, we evaluate that. There are staged levels where if you're approaching some threshold, a yellow light goes off, and then the yellow light starts blinking. So before you get to the red light, as an operation, you have changed your withdrawal so you don't have that negative impact on the surface water source. We also look at the groundwater resource itself. Now, in many instances, a company that is extracting water and selling it is going to have a personal interest in making sure the quantity of that aquifer is sustainable. We can verify that as well because we understand how much is coming out of the aquifer and we understand recharge over the long term. So we can verify, are you in fact going to pump this thing dry and then skedaddle out of town and leave the state holding the bag? I would argue that all of these regulations, and when you look in the laws, and the laws have been recently tinkered to make those three programs equivalent, that we have to protect for existing uses, we have to understand all of the cumulative withdrawals within the watershed, and we have to protect the statutory uses that are designated for groundwater and surface water. I don't think we're missing anything in the regulatory framework. So we don't see what adding the public interest to the private property of groundwater gets you, nor do we see that there is any disconnect between groundwater and surface water regulation. If anything, and I wasn't planning on speaking this way, if there is a hole in some of these unforeseens that we're looking at, Yeah, I don't think we have a long-term understanding of where water resources are going in the state of Maine. We have the framework in place because you created the Water Resources Planning Committee. You've charged us with the tools to evaluate on a watershed basis, supply versus demand. We have screening level understanding about where conflicts may emerge. Do we have a handle on predicting conflicts 20, 40, 60 years out? Nope, not yet. So I think the question for you is, are there enough resources in that longer-term planning framework? It exists, it's coherent, it's got the right tools, but make sure that that look-see is appropriate. And I would say, you don't need to make groundwater a public resource in order to do that either. It's really the motivation to protect the resource regardless who owns it.